In this case, Sijehama held the rights to mine coal in an area near Heathcote in New South Wales. Exploiting the coal in that area was beyond their financial capacity, and so they were looking for a joint venture partner. That's where Coal Cliff came in. The parties signed a relatively short 10-page heads of agreement, which included this provision. The parties will forthwith proceed in good faith to consult together upon the formulation of a more comprehensive and detailed joint venture agreement and any associated agreements, which, when approved and executed, will take the place of these heads of agreement. The heads of agreement did not include any umpire or other mechanisms to resolve any deadlock in any negotiations. During a period of some years after this, the parties worked on the joint venture agreement, but there were a number of real stumbling blocks on boring issues such as how they were going to treat certain tax liabilities. Eventually, the negotiations fell apart and they all ended up in court. Now, we know that an agreement to make an agreement can't be enforced, but what about an agreement to negotiate? President of the Court of Appeal Kirby said, provided there was consideration for the promise, in some circumstances, a promise to negotiate in good faith will be enforceable, depending on its precise terms. In other words, what the party is promising is merely a promise to participate in the negotiations, not actually promising to reach agreement at the end of it all. However, he carefully said that whether the agreement would be enforceable would depend on its precise terms. In this case, he said, there were many such differences at the time of the heads of agreement, and a number remain, even 3 years later when negotiations were finally broken off. A court would be extremely ill-equipped to fill the remaining blank spaces and to resolve questions which 3 years of painful negotiation between the solicitors for the parties had failed to remove. In other words, there was no problem with the concept of an agreement to negotiate, but in this case, the heads of agreement left so much out that when the negotiations broke down, the parties weren't actually left with an enforceable contract. From this case, we learned that an agreement to negotiate is a valid agreement, especially where an umpire is established to resolve deadlocks.